Welcome and good afternoon, everybody. My name is a consultant with the CUTS Institute for Regulation and Competition, or CIRC. I am delighted to have Dr. Orr Brooks as our guest speaker for today's webinar. Amongst the audience, we have distinguished competition law and policy experts, antitrust lawyers, antitrust enthusiasts, and students. I want to take a moment to personally thank each and every participant for showing up to this discussion. The CIRC strives to be at the forefront of exploring regulatory and policy issues relating to the fields of law, economics, and public policy. Let me now talk about Dr. Orr Brooks, who insists that I call her Orr. Orr is an associate professor of competition law and policy at Leeds University School of Law. She serves as director of the International Academic Society for Competition Law, Competition Law's British chapter, and as deputy director of the Center for Business Law and Practice. He has an interdisciplinary academic background, combining law and economics. Most of her research revolves around international and comparative competition law. Within those broad areas of research, she is particularly interested in studying the boundaries of competition law and its interfaces with other forms of market regulation, besides the manner in which procedural and institutional aspects of enforcement inform the substantive scope of the law. As far as research methodologies go, Orr is an empirical research enthusiast. Presently, she leads two empirical projects. The first project is called the Priority Setting Project, where she has joined hands with Dr. Kathleen Sears of the Amsterdam Center for European Law and Governance to study how antitrust regulators decide their enforcement priorities. The Priority Setting Project involves interviews with senior members of regulatory authorities to understand how prioritization decisions are made. The first stage focuses on the national competition authorities of the member states of the European Union. The second stage, supported by the United Nations Conference on Trade and Development, will research enforcement in developing countries. The second project she is involved with is called Beyond European Competition Directive Plus, empirical study mapping judicial review of national competition law decisions, an international project based on collaboration amongst academics from multiple jurisdictions. It constitutes the first ever mapping of judicial review in relation to antitrust law enforcement in the United Kingdom and the European Union. 28 teams composed of jurisdiction-specific experts set out to collect data to develop evidence-based assessments of the workings of national courts. They record several quantitative and qualitative variables for every judgment under scrutiny. Dr. Brooks' monograph on the role of public policy considerations in the enforcement of Article 101 of the Treaty for the Functioning of the European Union was published by Cambridge University Press in 2022. And she has also edited a research handbook on abuse of dominance and monopolization with Professor Pinar Ackman of the University of Leeds. Before joining academia, Professor Brooks worked as an associate attorney. The practice area was commercial litigation. Here's where I would want to turn the audience's attention to the law and policy context for this colloquy. Today, competition law and policy find themselves at a crossroads. Arguably, the new consensus in antitrust academia across the world is that traditional competition law enforcement doesn't adequately capture, much less remedy, the novel harms emanating from the digital economy. That's because the economics of digital markets is markedly different from the economics of traditional markets. In a report titled Anti-Competitive Companies, the Standing Committee on Finance of India's lower house of parliament states that digital markets are characterized by, quote, massively powerful increasing return to size economies. Those increasing returns, the report goes on to state, quote, result not just from traditional scale and scope effects, but also dramatically powerful learning and network effects. As a consequence, digital markets lack the kind of fairness and contestability one can find in traditional markets. Some of the ostensibly, and I stress the word ostensibly here, novel harms flowing from these peculiar market dynamics are killer acquisitions, anti-steering provisions, algorithmic self-preferencing, anti-competitive data-related practices, source bias, etc. Not just India, but jurisdictions around the world are deliberating whether antitrust law in the digital economy needs a complete overhaul. The European Union and Germany have devised ex-ante legislations that place multiple restrictions and obligations on the conduct of digital behemoths, and the United Kingdom has come up with a draft bill. It is against this backdrop that Or will share her views on whether traditional ex-post competition law enforcement can tackle the novel harms that supposedly emanate from the digital economy. In doing so, she will also share her views on the economics of digital markets. In particular, she will focus on data regulation from an antitrust perspective. The next part of our presentation will discuss the pitfalls associated with the enforcement and implementation of a legislative initiative like the European Union's Digital Markets Act. Right after, her presentation will segue into what principles should undergird a sound ex-ante regulatory regime for digital markets. Toward the end, Or will explain how the European Union's block exemption regulations have the potential public policy ends, how that could be relevant to the digital economy regulation. Or will hold the floor for 20 minutes. After that, she will engage in a free-flowing discussion with the audience. Over to you, Or.
Thank you so much for this lovely introduction and for the invitation to come and speak to you all. And I'm really looking forward to hear your perspectives, your insights, and the debate after the presentation. Let me try to share the screen. Does it look okay?
Yes, I can see the slide. I can see the
perfect.
Slides.
I needed somebody to nod. Perfect. So today, indeed, I will try to talk about the competition law regulation of digital markets and data more generally. And while many talks and many scholars focus on the question of what should be the content, the substantive rules governing digital markets, I will try to offer a different perspective and focus more on the question of how. So what kind of regulatory tools we should use to govern digital markets, and especially try to give perspective of not the traditional big competition authorities that we think about when we think about governing digital markets, mostly the US, the EU, maybe Germany, but also how smaller competition authorities, authorities with less political backing or less experience in developing countries, for example, what kind of tools they can use in order to effectively govern competition. So just as a starting point, when it comes, one of the main challenges to regulate data and digital markets from a competition law perspective is that it's a polycentric task. Many different public policies, economic and non-economic aspects. This is quite different from the direction the traditional competition law enforcement is going at, especially in the past 20 years. So we know that from the beginning of this millennia, more and more competition law jurisdictions across the world have embraced the consumer welfare approach, so a monolithic approach to competition policy, where the main aim is to increase the welfare of consumer. The main focus is on economic efficiency, and other public policies, with some exceptions and some different trends, are seen only as secondary or even as irrelevant to the work of the competition authorities. When it comes to data, this consensus does not exist. I think quite the opposite. It's quite clear that competition regulation of data is not only about competition and not only limited to the competition tools or the competition aims we currently have. We can think of it quite generally around those 4 categories of aims or motivations for the regulation of data. The first one would be competitiveness. So we can see we have elements here that are very similar to rules about anti-competitive agreements and abuse of dominance, so to prevent cartels and abuse of dominance. But there's also motivations going beyond what is normally captured by the traditional competition tools, like regulation of ecosystems more generally rather than specific practices, at governing network effects of vertical and conglomerate effects that are being captured only partially by the current rules, and issues like killer acquisitions, where it's difficult to capture by most current merger regimes. In addition to that, we have the motivation to just use competition law in a way to ensure data protection and privacy. So the most famous case is the German Facebook case that was recently also heard in front of the European Court of Justice. And the idea behind that when we have market power, companies and highly dominant companies can ask excessive data from consumers that they couldn't or wouldn't have asked if the market was more competitive. There are also issues of fairness and innovation. This could be linked to order-liberal traditions and order-liberal aims of competition policy going back to the 30s and to the 50s. The ideas behind that competition regulation should also allow every person, every company, small and medium companies, incumbents to access the market and to allow them to participate. And the idea that by allowing small and medium companies to enter the markets, this will also bring innovation. Finally, the idea is that lack of competition or excessive market power also harms democracy. So this goes quite away from the traditional competition law aims. The idea that when the control of media, or including social media, is concentrated by the hands of only few, this can harm the process of democracy, the exchange of ideas, and will also couple economic power with political power. And I think Cambridge Analytica is maybe, the scandal is maybe one example of this types of concerns. So we can see a polycentric task, multiple perspective, multiple perhaps conflicting interests that need to be weighed by the competition authority, which is quite challenging. Around this background, there is, I think, more or less an agreement by now across many competition law authorities and international organizations that traditional competition enforcement, again, anti-competitive of dominance, is ineffective when it comes to the regulation of digital markets. Several reasons, but I would like to highlight a few for the purpose for today. So the OECD have summarized it very nicely in a report from 2021 titled EX-ANTE Regulation of Digital Markets, that traditional competition law enforcement is too complex, too slow, and too specific. Too complex because traditional notions or traditional elements of the competition law prohibitions do not fit nicely when it comes to digital market. So we have the concern that zero pricing, for example, and network effect, and the question, how do we define markets, how we define dominance or abuse of such dominance in this context. Too slow because competition law enforcement can take years. I think the German Facebook case is another example, but if we think at the 90s or the beginning of the millennia about the Microsoft case in the EU, it takes years, if not almost decades, to run a case from the beginning to an end. It goes through multiple stages of appeal and review, meaning that by the end, many times the decision is no longer even relevant, especially when it comes to fast-moving market like many of the digital markets. And finally, too specific, because traditional competition law allows only to target specific agreements, specific behavior, and it has only limited tools to look at the ecosystem as a whole. And therefore, maybe we need different tools. Another problem with the traditional law enforcement tools is that they offer very limited remedies. So even if we, after this decade, manage to get to a prohibition decision, competition authorities often do not have the tools to actually protect competition or restore the markets to the situation without the abusive or anti-competitive behavior. The last point takes slightly a different perspective, maybe one we're not used to when we think specifically about competition law, which is more linked to good governance principles. If we just use traditional competition law enforcement to govern digital markets, it means that many of the polycentric motivation and the task of balancing between those polycentric motivation falls on independent regulatory authorities, the competition authorities, and courts, which develop them on a case-by-case basis. In such situation, we don't have a democratic debate between parliaments, governments, civil society organizations, think tanks, NGOs, and so on, to think how we want to see the future of our digital markets, and to try to think more fundamentally about what the rules should be. As a result of all of those problems, also we see under enforcement of competition law in digital markets, especially when it comes to the not superstars competition authorities of the world. So beside the EU Commission, the US, to extend Germany, maybe a bit the CMA in the UK, most other competition authorities do not have the resources, but also the political backing and maybe the expertise to tackle those big cases, especially because they already have a lot of other workload and a lot of other markets to govern. Because of those flaws, and also some others, the EU, but also with the backing of many international organizations, has trying to shift to a different approach to regulate digital markets using the ex-ante regulation. The DMA is probably the perfect example that we can think of, but we see other initiatives in Germany. I was told in Germany, familiar with, so if somebody has a background, I would love to hear about that in the discussion. Ex-ante regulation allows us to overcome some of the problems that we discussed because it brings in the discussion the issue of fairness. So fairness is a clear motivation of the DMA, is repeated many, many times throughout the regulation, also in the policy documents leading to the regulation. And fairness allows us to tackle exploitative behavior, which does not fit nicely with the consumer welfare standard or approach, and to look much broader also on entering markets, acting fair to small and medium competitors or to consumers. Contestability of markets is another more economic notion that the DMA has introduced. The idea that markets and the marketplace should stay open, contestable, that if we have efficient competitors or those that can bring innovation, they can enter the market. And this expands the tools that the regulators have to tackle exclusionary behavior beyond what the traditional abuse of dominance provisions allow in many authorities. The DMA and other ex-ante regulation of digital markets also talk about innovation, and innovation being a clear objective of the policy, of allowing transparency in the way that markets are being governed, that markets are being managed also by those big digital giants. This leads us to the question of what is better, but just one step before that, how we even try to measure what is a good regulation and what is the best way to govern markets. Should we go with the traditional competition law prohibitions or shift to ex-ante regulation? I think as competition law specialists that we know that field, we are so excited about it, after we have the pitfall of having a very narrow view. So competition law scholars, and I think also policymakers, often talk with only other competition law specialists and enthusiastic, and we kind of lose sight about a lot of work that's being done about regulation, about law enforcement theory, and there are so many great theories that were developed by many. You can see put it here. So I really recommend this book. It's called Understanding Regulation, and by the authors that are listed on the slide. And this is one fundamental textbook that can teach us quite a lot how to measure. So when we talk about impact assessment, also how to approach techniques for regulation. The author suggests those 5 benchmarks or measures of what is good regulation in any field of administrative law enforcement. And I will try to compare the competition law prohibitions and ex-ante regulation based on those 5 measures. As you can see, those are the 5 measures. So the question of legislative mandate, that goes a bit to the idea of democracy. So who has the power to adopt decision to govern markets? Is it independent regulatory authorities, which can be very good at what they do, but they are normally not elected, are not accountable necessarily, and might not see the full picture, but only focus on their area of expertise, like competition law, and they might not have the broad polycentric view also about other concerns. The second measure is, do those who apply the law are accountable to the public, but also to the other democratic institutions? Is due process ensured in the sense of allowing right of defense, allowing wider public participation in this discussion? Do they have the expertise? And is enforcement of this regulation is efficient? Based on those 5 parameters, we can kind of come with this balance of what is better, ex post, the dark blue, or ex ante, which is light blue. So when it comes to legislative mandate, I think there is the clear winner is ex ante regulation, because ex ante regulation, like the DMA, allows to have a discussion specifically about the regulation of digital markets, to have the discussion about how to balance the different motivations and the different aims of such regulation, and to involve as many people, many groups, business and general public in this kind of discussion. By comparison, the ex post prohibition, if you take the EU example, for example, so Article 101 and 102 TFEU have entered the European treaties in the 50s. They're based on French law, almost word to word, going back to the Middle Ages. Of course, there was no discussion about digital markets back then, and therefore the legislative mandate or democracy considerations are less pronounced. Similarly, when it comes to accountability, I think here ex post and ex ante regulation weigh quite similar. In both cases, the competition authority, for example, the Commission, would need to explain to the public, but also to the voters, how it applied the law and why. In terms of due process, ex ante might have some benefit because, for example, the DMA have introduced a procedure specific to the regulation of digital markets, allow for opportunity for discussion, for negotiations with those big tech giants, and for public participation, which is maybe lacking when it comes to ex post, especially because it takes so many years. Then we have the question of expertise and efficiency. The DMA and similar initiatives are often being justified because even within the competition authority, the task force that will be in charge of applying the DMA has much expertise, have economists, lawyers, even people with technology background that can apply the specific regulation in this specific field. And therefore, we can assume, or at least we want to expect, that the authority will be highly expert in applying these issues. By comparison, the ex post to applying the regular prohibition of abuse of dominance and cartels will be less successful because even within the competition authority, they might not have the specific skills, tools, and expertise to tackle those markets. For the same reason, because ex ante allows for a much faster procedure with people with having the relevant considerations will be examined, and the people have the skills will examine that, it's expected to be much more efficient. However, those two last benefits of ex ante regulations are at least questionable when we are talking about competition authority beyond the superstars of the EU Commission, the US, and Germany. There's a real concern that when we come to smaller competition authorities in developing countries, but not only. So, for example, the Dutch Competition Authority have expressed concerns that they do not have the manpower, the expertise, and the resources to apply the DMA or similar regulations in digital markets, because still it requires a lot of resources to develop this expertise and to allow for efficient enforcement. When it comes to competition authorities in developing countries, already having a relatively small staff, small resources, and limited expertise, we can imagine that those benefits of ex ante be even smaller. If we agree, if I manage to convince you about this premise, then the balance between ex post and ex ante regulation is not that clear. It's not that clear that ex ante regulation would work better, despite the arguments were made by the OECD and other leading international organizations and scholars. But we still know that ex post regulation doesn't work very well either, and that there is considerable under-enforcement in those jurisdictions. So what can we do? This is my last slide, and I will try to go over it quite quickly so we have time for discussion. What I propose, and I also developed this argument in an article you can see in the QR code. I will also share a link after I stop sharing the screen. Is suggesting that block exemption regulations could be an effective tool to regulate competition in markets where we have strong and convincing public policy considerations that play a role. So digital markets is one example, but you can also think of the regulation of labor. So in the gig economy, for example, so how we balance between competition law and protecting weak employees, sorry, or casual employees. It could be used to protect sustainability initiatives that are being taken by many of the member states and so on. Just as a quick overview, block exemption regulation is a tool that was developed in EU competition law since the very first one were in the 60s. And the idea here is that we have very clear list of practices that although that technically they can be seen anti-competitive, the legislator and the competition authority declare from the outset be seen as infringement of the law, or that it will not be enforced by the relevant competition authority. Block exemption regulations are adopted for only a temporal period. I think in the EU, typically somewhere between 5 to 10 years. And after this period, they are being reassessed. An impact assessment is being undertaken, and they either can be replaced or extended to another similar period of time. What I want to suggest here is a block exemption regulation to govern data could actually help us avoid many of the pitfalls that we saw to both ex-ante regulation and traditional competition law enforcement, and that this might be especially useful when it comes to competition authorities that don't have the resources or the expertise. Block exemption regulation will score quite high on the legislative mandate benchmark because they are specific to a specific area, even within digital markets, and they're very detailed because they need to be very clear and very easily applied by different types of undertakings. So they will be adopted after a democratic discussion, and also for a specific amount of time that can be reviewed as the markets, as the technology changes, and as we gain experience in regulating those markets. Accountability is somewhere in the middle, because adopting the block exemption regulation will score high in accountability because it's law, not just development of case law, with wide participation. It's slightly low because most block exemption regulations, we don't see how it's being applied because undertakings self-assess their behavior within the block exemption regulation. Due process is likely to score quite high because block exemption regulations are transparent, are very certain because they need to be specific, and allow a uniform of decentralized enforcement, where you have a competition authority with different branches, because they only require limited discretion or interpretation from the competition authority applying it. Expertise, again, it can score high even in developing countries or countries with limited resources, because it allows for a polycentric view. So from the outset, when we adopt those regulations, they take into account the different considerations. They allow for competition law perspectives, and applying them is quite easy. So the competition authority will not need to weigh the whole different objective or balance in the specific case, but rather this was done by the legislator when adopting the block exemption regulation. Efficiency, block exemptions are probably the most efficient tool you can think of. Actually, the European Union adopted them in the 60s because it needed a tool to quickly look at thousands of agreements that were notified to the Commission. They involve very low compliance costs and application costs, so both for the competition authorities and for the companies, and they're highly efficient because they're flexible. Each block exemption regulation, as I said, is adopted for a specific period of time, and that means that if we see that there's a problem with block exemption regulation, it's very easy to fix it, to change it, And if we see that the markets develop different what we expected, again, we can just 5 years later adopt a different type of block exemption regulation without needing to change the whole system, like, for example, what would be required if we want to change the DMA or the competition law prohibitions. So we'll end my presentation here, and I'm very much looking for your challenges and discussions. I know it's a bit controversial to suggest that.
Thank you all for what was an excellent presentation. It was thought-provoking, informative, and concise, all at the same time. I will now open the floor for questions from members of the audience. Please go ahead and ask your questions of Dr. Orr. Questions?
I think there are some questions which Macquarie has sent directly to
Mr. Asher.
as a book.
Yes, Mr. So Mr. Asher is also raising his hand. So we will...
Yeah.
Sorry, you were inviting me to ask my question? It's Alan Asher.
Yes,
well, thank you.
Please go ahead. Yes.
Well, thank you, and I appreciate the presentation. I think you brought out quite clearly the issues on either side of the debate. Although I would like to add a slightly different dimension, and that is that I think very many of us now believe that competition policy has moved into more of a neo-Brandeisian stage, where we're not so tied up with a strict allocative efficiency measure, and that laws increasingly are looking at some other important social goals. But really, even aside from the relaxation of those tests, for the best part of 50 or 60 years, in effect, competition laws have built in some of these ex-ante provisions. And by that, I've always felt in Australia, where there's a unified regulatory system where both competition and consumer protection are operated by the same body. And I was also a member of the board of the OFT for 5 years, again, where both competition and consumer protection were administered by the same body. And I never had any difficulty in seeing the role of competition as about maximising output and minimising price. That's a very common view, but that to understand that competition alone doesn't really deliver the sort of consumer outcomes that we want because of things like product safety, deception, poor performance, all of those. And so pretty well every jurisdiction has a set of consumer protection laws which tend to operate both in an ex-ante and ex-post way. And so when it comes to digital markets, I can't think that there's any reason that we shouldn't incorporate some of those features there. And I just give to conclude, so I don't take up too much time, I'd argue that we've got a useful test in law, and that is the standards that the law would use in granting an interlocutory injunction, where if you can show that there'd be a sort of harm that can't be fixed by ex-post laws, then there's a justification for intervening early to preserve the status quo or something like that. And so when it comes to breaches of privacy, where people might lose their identity or money or lots of things like that, then I think there's absolutely good reason to have some upfront laws that regulate how data is kept and stored and where it's processed and things like that. But I think I agree with you that we don't want to lose the dynamic effects of competition either. And so it should be approached as a struggle where people do need to justify, and this could be done through well-crafted block exemptions, but through other means as well. But overall, my conclusion is, let's keep a really tight focus on what we want the law to do, not get tied up with the abstract jurisprudence, but the practical issues of maximising output, minimising price, but in a context where consumers are the winners.
Should I respond now or in the end? What are the rules?
You could respond.
Yeah, though, thank you. I mean, many great points. I probably agree with most, if not with all. Just to respond to some of the comments about the change in goals or the decline of the consumer welfare standard or approach, I agree. I think we see it as a new trend, or I think it's changed. In the past 5 years, I think COVID also kind of pushed it. We can see that every year more and more competition authorities are a bit more open to at least publicly admit that they're not really following the consumer welfare approach. In my empirical research, you can see the book here. Yeah. I also say that in practice, we see that many of them did not really follow the consumer welfare approach in practice, but it was more of a standard or in case of some. I think the question is how they take into account those broader public policies. Many competition authorities, the European Commission would be one of the prominent examples, do it by enforcement priorities. So, for example, when it comes to sustainability, but also in protection of employment rights, they're not saying that those practices are not anti-competitive, that they cannot be captured under Article 101 or 102, but rather they say that as an enforcement priority, we will decide now not to focus on those agreements. I argue that this is highly problematic because either private parties can bring private action that is increasing in Europe and the UK, or other competition authorities can take similar public enforcement because the Commission guidelines are not binding on them. And therefore, this does not provide legal certainty to undertakings. And it means, and there is empirical support that they'll just choose not to take the risk and not engage in this type of behavior. And this is where I think ex-ante regulation, for example, in the form of block exemption regulation, but we can think also of others, are more effective. More effective both in protecting competition and in promoting those other public policies if we take them seriously and not just as a lip service. Yeah, with the other points, I probably agree.
Or can I ask you if it seems to me that Mr. Macor, if I'm pronouncing his name right, Wilson, has asked you a direct question in your chat box. Can I request you?
Maybe in the other computer. Oh yes, now I see. Do you want me to read it out loud or?
Yes, please, for the benefit of the audience. Thank you.
Okay. The question is, as regard the enforcement, what would be my advice for young competition authorities, especially in Africa, in enhancing competition law enforcement, amidst the challenges as the lack of necessary tools to protect or restore competition and resource constrained? Yeah, okay. And then the second question is quite similar. Yeah, so this is a very big question going also beyond the regulation of data. But I will try to use maybe insights from the priority setting project, which we have already mentioned today. From interviews that we had with competition law enforcement authorities, we didn't have much contact with Africa. So if somebody has a contact person and you would like to put us together, I would really appreciate that. We see that there are different hindrances or different hurdles to competition law enforcement, but one of them being is that the authorities on the one hand had limited resources, and on the other hand, especially in new competition authorities, many authorities are quite reactive. So many authorities have an obligation, for example, to examine, investigate, and issue a formal decision with respect to any complaint or any informal information about possible agreements coming to their attention. Some competition authorities have a notification system, not only for mergers, but also for anti-competitive agreements, for example. As a result from that, much, if not all, of many of the smaller competition authorities' resources are directed just at responding to complaints or just responding to notifications, meaning it had very limited time and resources to focus on its own investigations, even in traditional markets. Opportunity to adopt its own agenda, but also its own speciality. So, for example, we see that in many countries, bid rigging or forms of interference with governmental contracts is a problem. But because the competition authority only responds to complaint, it does not have the time to take those cases, develop the case law, develop their own tools, expertise, internal body of knowledge to respond to those cases. So I think one of Kati Chedras and my recommendation for developing countries, sometimes it requires change of law and not just action by the competition authority, is to try to identify areas of priority. Could be either sectors or certain types of practices, and focus much of its resources on that. Probably digital markets will not be a good candidate for that because it's so complicated and because we're talking about also defendants with so many resources and so many powers. But you can think of looking at construction sector, which often has problematic practices, at certain types of consumer goods, food, and as a market that are also more important to consumers in developing countries. I hope this helps. I know it's quite general.
Thank you all for that elaborate answer. I just want to bring to your attention and the attention of members of the audience that Mr. Manas Chaudhary, who is a doyen of antitrust law in India, has asked a question about enforcement in the Indian perspective. Or you can, everybody can kind of read those his.
I can't see them.
Message. Right, I'll read it out for all,
okay,
for everybody.
Thanks.
When the Competition Commission of India was being conceived in 1999 to 2000 in India, there was fear amongst ex-ante sector regulators that the CCI being may become a super regulator, but it was not agreed to by the policymakers. Are we now promoting a contrarian view in 2023 and in effect promoting the CCI to be the real super regulator? I think what really seems to be, I just kind of, or for your benefit, tie this to the wider law and policy debate surrounding ex-ante regulation, where, whether ex-ante regulation really breaches the bounds of antitrust is traditionally understood, and whether that kind of puts enforcement authorities like the European Commission, Germany's Competition Authority, or for that matter, the CMA in the UK, in the position of a super regulator, or is it rather less, while it may, there's that view that it breaches the bounds of antitrust, but really is so I just ask, what know your opinion on that?
Yeah, this is such a challenging decision to make if you want to have your own competition authority or you want to have it together with sector regulators. I think the UK provides a really interesting example to that, because in the UK, in addition to the CMA, which focuses on competition and recently opened also regional offices to try to capture competition law practices mostly outside of England, we also have sector regulators. The British sector regulators have the power to enforce competition law or to choose to enforce other rules of sector regulators. From a theoretical perspective, I think it makes a lot of sense because competition authorities can choose what is the best tool to try to answer a lot of the debate we had today. So, what are the benefits of ex-ante regulation, sector regulation versus competition law? The problem is that the problem is that in practice, we see that the British sector regulators do not enforce competition law. There are few, very, very few, I think 5 in 20 years, decisions where they did decide to enforce competition law. The British government and legislator and the Court of Auditors. But even then, they mostly enforce competition law by using commitments or other negotiation and softer tools. And therefore, it shows that when it comes to practice or a bit of the political science behind regulation, the questions are even more broader. And there is a concern that in the UK, there's actually under enforcement because there's not enough hard enforcement of the competition rules.
Right. I hope that at least partially answers Mr. Chaudhary's question. He has raised his hand, so please.
So maybe no.
Yeah, I
Yes,
know
over-
that has always been a turf war between sector regulators in India because they actually regulate ex-ante sectors. And most of them, for example, if I talk about electricity, it was unbundling. The generation, transmission, and distribution was in one body. And the Electricity Act has actually unbundled all the three sectors, and still it is ex-ante. What I am trying to understand as a lawyer, how do I justify during the course of a litigation these theories in terms of a concrete evidence so as to ensure a judicial body, say for example, court or a person who is heading a tribunal as a judge, to really see it in black and white evidence of breach, evidence of contravention. If we are able to do that, then I am fine. But if not, then what I am anticipating as on today, 2 to 3 years down the line, we may have to bring in per se illegal criminal sanctions against big tech companies. Otherwise, it would be just an academic exercise only. It would not result into a decision. It would not be able to really reach to the conclusion what we are trying to achieve. If we are thinking in terms of a per se illegal criminal sanctions, then I think we are going beyond cartels. This is my whole problem as a practicing lawyer. If I'm given an opportunity to argue before a court, how do I justify the evidence? That is the real challenge to me. In terms of India, I'm not talking about EU because EU is a European common market having 28 independent national authorities as well as EU, which we don't have. So we have got a very strict domestic competition agency plus n number of sector regulators who are all ex-ante. That's the problem on hand in India. That's my limited problem.
So the problem, just that I understand the question, so the problem is that judges also prefer to go through the route of ex-ante sector regulation because it's more clear in comparison to competition law?
No, in case of a sector regulator in India, the regulator, once it is, because, you know, in a sector regulatory landscape in India, the regulations are available on the website for the sectors, players, sector stakeholders to abide by that. In the event of a failure to abide by those regulations, immediately the regulator steps in to correct that. And if the party who has been agreed by that intervention by the regulator might move to the appellate tribunal for adjudication. So the adjudicatory process, in fact, starts at the appellate level. Whereas in the case of CCI, the adjudication starts at the CCI itself.
Yeah.
That is the issue, that in appellate tribunal, the CCI's orders are challenged. There is no ex-ante regulation available on the website for the parties to abide by or to breach. It is the law which is sufficient. We don't have any other regulation to abide by. On the contrary, in case of merger control, there is a regulation because it is a regulatory activity of the CCI. So the difference between antitrust and combination is very clearly laid out in the Competition Act. There is, the problem arises, how do I really match this ex-ante versus ex-post, which has been due process passed by the parliament.
Yeah, so I can see the challenge, and I think that many other countries face similar challenges. So I think in academia, we are praising the EU about the use about by effect restrictions, and that we don't look about per se or by object, but it's much broader. We look at the effects and so on. Especially in the second empirical project that was mentioned, where we are coding all of the appeals of competition law enforcement in front of national courts. One very clear finding is that there's almost no by effect enforcement by national competition authorities and later on litigation in front of national courts. So in the EU, although theoretically it is possible also to bring a by effect case, we see the majority, but majority I'm talking about high 90% of the cases are by object or by object and by effect, which is kind of a bit of yeah, I think a fake way to put it by object restrictions. It's kind of a fiction that competition authorities sometimes use. I think that this could be another reason why we should use block exemption regulations. So we can kind of admit that by effect doesn't work, especially when we talk about new areas of law like digital markets, where we don't have a body of case law over decades and decades that has been accumulating. Genuinely, we don't know what are the limits of illegal behavior and what it should be. And this is why adopting some form of ex-ante regulation, even if it's competition law ex-ante regulation, could be highly beneficial. The question of what kind of regulatory tools to use really depends on the national system, and I admit my limited. So it could be by block exemption regulation if this is something that is available in your jurisdiction. If not, it could be sector regulation and using the state action defense. So if there's a certain conduct that is allowed by sector regulation, competition law will step aside and not intervene. Guidelines, even informal guidelines, could be quite useful. So if the competition authority in India can adopt guidelines on how it sees the interpretation of the law, even if it's unbinding, this could signal both to the courts and to undertakings what are the limits of not illegal behavior according to the authority. So this could be perhaps a first step, but definitely a challenge, I agree.
Yeah, so I would not like to really block the questions of other people. What I'm trying to see as of now, that the whole objective of creating these regulators post economic liberalization in India is to minimize the work of court and expeditious disposal of matters so that the market functions properly. Now, if we are adding some new tools to that, it should actually improve the position rather than it becomes a confusion. That's my only worrying problem, because as on today, as you rightly said, perhaps the authorities may not have appropriate manpower to handle. Even if it is being brought into India, how are we going to have the manpower? Because as on today, I am sitting on the 23rd year of competition agency in India. Not a single law school of repute in India teaches competition law as a permanent subject. It is an elective subject, optional subject. So we are not creating the corpus to really have the CCI the benefit of the manpower within its domain. We are just learning by doing. Will this work in a digital space which is so technologically strong? That's my biggest fear. And invested so much of money are left to high and dry because of ignorance of the judiciary or ignorance of the authorities. I think it would be doing far more disaster than really benefit.
I agree, and I think that maybe clearer rules, simple, so they won't capture all type of anti-competitive or problematic behavior, but clear and simple rules might be a way to go forward. And as I tried to convince you in the presentation, block exemption regulation could have a benefit because they can be reviewed. So you admit from the outset that it only will cover the next 5 years. And after 5 years, you will update them according to the changes of the market. And I will put in brackets, according to the experience also of other competition authorities.
No,
So
agreed. Only one problem becomes, end of the day, law must be implemented, enforced to the logical conclusion the way the parliament intended.
Yeah.
It should not be left open to interpretation. And since the digital markets are so dynamic, if every new order is a new interpretation, then ultimately the judicial discipline is going for a 6. You do not have consistency. You do not have a precedent setting in the system. These are all issues which, from my own experience of practicing law for 35 years, unless there is a predictability, there is a assurance of a judicial precedent, it sometimes becomes, you show me the man, I'll quote you the law.
Yeah, I think I'll put very shortly, so just to respond to that, and I'm not saying block exemption regulation is perfect, so I'm sorry if it sounds like that, but just something also I mentioned in the paper. In the EU, a big part of the legitimacy of the block exemption regulation and the legitimacy in the eye of the courts, it was that the court influenced the block exemption regulation, many of the block exemption regulation. So we see exemption regulation has been discussed and was open to public consultation, the court adopted a decision explaining what the law in this area should be. So that was for franchising, for example, very clear about research and development, blocking exemption regulations, and so on and so on. So blocking exemption regulation also invite comments from the judiciary. And I think if you manage to do that, either formally by inviting them to submit comments or inviting judges to be part of the committee that proposes and adopted the blocking exemption regulation, or informally in whatever way that would be possible, maybe that's a way to overcome that and to kind of align the interests of both the judiciary and the competition authority. So we certainly see that this is happening in the EU.
Okay, thank you. Thank you.
Thank you. Thank you.
I would encourage others also to come forward and
Yes.
ask questions. But in the meantime, I want to ask a basic question that the kind of delays you were referring to in your one of the initial slides when you explain key challenges with the ex-post regulation, and that it takes longer because of the appeals, primarily appeals. I mean, that's the reason. So I mean, those rights will be available to affected parties in the case of ex-ante regulation also. So do you think the regulators will be able to insulate the action from the appeal action, and therefore the desired action will take place and it will not be delayed? I mean, is this the presumption?
I think it's definitely the presumption. The question of if it's a reasonable presumption is something separate, and of course I see your point. I think what is different with the ex-ante regulation is at least it should be much more specific and much more detailed. So when we are looking at, I'm thinking of the Microsoft case of the 90s in the EU and the US. So there we really had huge policy questions, right? So it's not only that we had appeals looking at the fundamentals of competition law. So how we define market, what is an abuse, the limit of that. So almost all of the case law up until then was challenged. So we're talking about huge scope of dispute. If we want to be more cynical about it, huge scope of opportunity for those companies to try to delay, because so much had to be discussed. When it comes to ex-ante regulations, at least if they're being drafted properly, then the scope of the dispute will be much more limited, because the rule should be clear. If there's a question, and I'm sure there will be questions, there will be limited, and if the courts will be up for the challenge, they can try to eliminate much of opening all of competition law to be challenged and to be disputed. Is it naive? Possibly. Well, we'll see.
Thank you, Dr. Thank you for the question. Any members of anybody else would want to ask a question? Please go ahead. It's 4:30 by the clock. One last opportunity to ask questions. I have a question, but I just want to say I have a question, but I'll probably ask that later. We passed time. So I'll just or do you want to say something in the end?
No, just thank you. As I said before, we are trying to expand our research also to work, especially I don't love the word developing countries, because I think it's much broader. It's not only developing, but also competition authorities which are smaller, newer, just less funded. Because as I said, we see similar problems in the Netherlands, which is probably quite developed. So if you disagree with what I say today, or just have ideas, or you would like, you're also providing training seminars for competition authorities on how they should set their priorities, or how they should go about regulating markets. So if you were interested or want to hear more, just get in touch. Thank you so much for the opportunity to discuss today.